Streaming. Ms. Campus is a member of the board, correct?
Yes, correct.
I just let her in, Brian.
Perfect.
Let's see.
Nobody's saying anything.
Hey, everyone.
Hi,
Hello,
hi, Francine.
Hi.
Hello.
Hi.
Okay, we got, let's see, we need Jean, Jill, and Gloria.
Valerie.
Valerie's here.
I'm letting Valerie in.
Hello, everybody.
Hello. Hello.
Hey, Dimitri.
Okay. Hey, Francine.
Hi. You feeling better, Loretta?
I do.
Good.
Thank you. Couple little glitches, but for the most part, a lot better. Like I'm
glad
very,
to hear.
still get tired, but
Yeah, it takes the wind out of you, huh?
yeah, definitely. At least I'm alive, right?
Hello,
Yeah.
Valerie.
Hi, everybody.
Hi, Valerie.
Hello.
Hey, Val.
Hi,
Hi.
Dimitri.
Oh,
2, 3.
Hi, Val.
Hi. Glad you're feeling better.
Thank you. Thank you.
We missed you.
Aw, thank you. Oh, no, that's not what I wanted to do.
Oops.
Anybody else in there, Brian?
We have a attendee, but not a panelist.
Okay.
Jill Perez, right? Let's move forward.
Yes?
Yes.
So we have 1, 2, 3, 4, 5, 6.
Hey, Lon, I didn't see you down there.
Hey, how are you?
I'm good. How you doing?
I don't see.
So we got 2 more, Jean and Gorov.
Jean and is that his first name?
Hello, Jill.
Shah, right? That's his last name. Yeah.
Hey, Jill.
Hi, Jill.
Uh,
Hi.
Hi.
Somebody else? No, both of those are public attendees. Give it 1 more minute and we'll start.
Jean's here.
Okay. And Gorov's here.
Okay.
Pro-
All right, we're going to get started.
All right, I'm going to start recording.
Perfect.
Okay. Good evening, Gorov.
Evening, guys. Sorry about
Hello.
Okay.
Hello.
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 You ready, Ralph?
Yeah, we're just gonna let Jean come in.
Okay.
Tried promoting him, it didn't take. Ah, there he goes.
You don't think I know that?
Ah, yep. Welcome, Jean. All right, looks like we have everybody. As soon as Jean's turned on. Jean, you can unmute and turn your camera on if you wish.
Okay, how do I do? Oh,
All right, Francine, as our order, you want to read the opening statement, please?
Sure. In accordance with the Open Public Meetings Act, NJSA 10-4-10, and the regulations governing remote meetings, New Jersey AC 53915, I hereby announce that adequate notice and electronic notice of this meeting was provided in a notice dated January 5th, should that be 2022?
No,
And-
it's noticed the year before.
Okay, 2021 and January 19th, 2022. That was sent to the Asbury Park Press, 2 River Times, posted on the bulletin board and on the main access door to Town Hall, filed in the clerk's office and posted on the township's website, www.holmdeltownship.com.
Roll call, please.
Miss Avron,
Here.
Dr. Blumenthal,
Here.
Mr. Burkle,
here.
Miss Campus,
Here.
Dr. Latif,
Here.
Mr. Luciani,
Here.
Mr. Opanatopoulos,
Here.
Miss Perez,
Here.
Dr. Shah.
Here.
Please rise for the Pledge of Allegiance and then stay standing for a moment of silence to honor police, military, and wounded or killed in action, and also all our first responders. I pledge allegiance
Allegiance to the flag
Flag.
of the United
United
States of
States.
America and to the republic for which
For which
it
it
stands,
stands,
one nation, under
under God,
indivisible,
with liberty,
with liberty and justice for all.
for all.
Thank you.
What? Oh, we just did it, we assumed.
First item we have is a memorializing resolution. This is an application that was heard in December, and our attorney has prepared the resolution. Francine, could you just read the brief statement?
Sure. 40 McCampbell Road, Tammy, Block 22, Lot 902 in the R40B zone. Applicant granted variance relief for driveway entrance gates of 9 feet in height where 4 feet is maximum permitted by ordinance.
Our attorney has prepared a draft resolution which was sent to the board members. Does anyone have any additions or corrections to the draft resolution as presented by our attorney?
Well, it may be a good idea to just let all the new members know that this is normal process. This is the end of the application process for applicants. It usually comes a month and a half after we actually vote on something. Anybody that votes in favor of the application is a permitted member to vote on this resolution. Obviously, if there's any changes or comments prior to tonight, hope they're, I ask that you get them to me prior to the meeting so we can make the final changes, but we can always make them and incorporate them by way of the passing resolution tonight. But if there is an attorney, we do send it to the attorney for their courtesy. If they have any comments to give us, not that they can change it, but they can give us their comments as well. We also send it to our professionals to make sure that we have detailed correctly the planning and engineering aspects. And I would say the most important aspect of these resolutions when you get them is looking at the special conditions to make sure that I've captured what the board has imposed as conditions throughout the hearing. There's only a couple when it gets a backyard variance like this, but as we get into more complicated variances and applications, in fact, you may have a list that's 15 or 20 special conditions. And it's just important that we capture those exactly as we've approved them. So for the new members, I just ask that you read those carefully and compare them to your notes. I mean, I do the same. I do take as detailed notes as I can through the hearings, and obviously Kate and Bob are good backups as well as Loretta. But there is a role to play when we get to this resolution. Is the point of my comment. So don't just vote to approve it. You should take a few minutes to look at least the special conditions to make sure it does capture what we've approved. That's
Okay. in this case, those who are eligible to vote on it is Valerie, Dimitri, Francine, and myself. Is there, just again, I have not seen anybody indicate that they had any additions or corrections, which
I make
hence
a motion to approve the resolution. And as
Second.
roll call of those eligible to vote, please.
Ms. Savran,
yes,
Ms. Campus,
yes,
Mr. Afanatopoulos,
Yes.
and Dr. Blumenthal.
Yes. Okay, the motion is passed, and so Loretta will be notifying the applicant
Mhm.
the next day or so. Okay, now we're going on. This is something new that haven't done in the recent past. But since there are a number of new board members, we thought it is appropriate to just have a workshop amongst us to talk about how we do things.
Ralph, if I could interrupt you just for a second, if we're gonna go into the training and we don't have any other business, I'm gonna leave the meeting.
You're perfectly free to do so.
So I'm gonna log off. If there's something that changes where we need to go back into session or some reason, if you just text me, then I'll log back on. But,
I don't anticipate. It's
okay,
just simply hopefully an informative workshop primarily for the new members, but I've always found you can always learn something new.
well, maybe, but let's hope in my case, that wouldn't be the case, as I've been practicing this for 30 years now, so let's hope not. So, all right, good night, everybody.
good night.
Good night.
Anyway, I'll start.
Ralph,
And
Ralph, if I could just give a quick caveat, as you and I spoke about before.
I was gonna go into that in
Yep.
1 minute.
So it's just
One is
important.
fair.
This is just an overview of various members that have experience of what they've seen, as well as the professionals of what they've seen and some of the tests that are required in order to approve or deny something. Just want to make it clear, because this is a public meeting and it is being recorded, that we don't want to talk about specific cases, clearly not anything that's on the agenda or coming up, because that's not appropriate. Anything we talk about on any application has to be in the public setting of the hearing. We don't want to be doing that at the grocery store, offline. We don't want to be texting each other, because all that stuff at the end of the day can be discoverable, and it can be grounds for someone who wants to object to the outcome of the hearing to file an appeal. And we don't want to ever jeopardize whatever we do here. It's a lot of effort for the applicant, whether we agree with them or not. And it's not fair to the applicant or the objectors to have something overturned because of, people not just participating in the hearing, but outside the hearing. So with that caveat, also to know that tonight, it's just anybody that gives an opinion is an opinion, right? We're not talking about specific cases, and it's not meant to be, it's meant to be more hypotheticals, and hopefully it's very informative, but I just don't want anyone to use whatever said tonight, 6 months from now and say, well, it was said at the workshop A, B, and C, and you didn't apply that standard to my application. So every application stands on its own. What we do with one application doesn't necessarily mean we have to do it to another. And every fact, really the facts are so specific to every case, even with this backyard variances, that no two cases really are ever alike. So this is more of an overview. And with that being said, we don't have to say that every time one of us speaks, but I want it to be clear to all the participants, whatever we say tonight is just informative in our opinion, and not meant to be a factual statement unless we're actually quoting the law as it's written. So with that, I'm sorry, Ralph, I didn't mean to jump in there, but I think it's
That's
important.
fine. To keep us on the even keel and following the law. Okay, I'm gonna just share my screen. Okay, so I've been involved with some of these things for 20+ years. Been here at the zoning board, planning board, involved with writing some ordinances. And this is my understanding, a summary of how the state of New Jersey has chosen to divvy up the responsibilities, the checks and balances between the various bodies in the municipality. I'll talk, this is going to be a high level. It's my understanding. And as we go through the evening, we'll get into greater detail about some of the engineering aspects, planning aspects, legal aspects. It's the actual laws that govern. I ask for, on each of the presentations we'll have tonight, to be more efficient so it doesn't take forever, because one can spend forever talking about these topics. Just to hold your questions till the end. What the municipal land use law is the New Jersey law that governs what we're doing. And this is a quote from the law itself. The purpose of the law, the intent and purpose to encourage municipal action to guide the appropriate use or development of all lands in this state in a manner which will promote the public health, safety, morals, and general welfare. Very general statement. And it's this law that delegates to the township certain authority to do these things. Whoops. And in a set of way of creating some checks and balances in the system, the state has deemed to split these responsibilities between the three bodies in the township: Township Committee, Planning Board, and the Zoning Board of Adjustment. There are three independent bodies. Each hires its own professionals. There also exist other volunteer groups like the Environmental Commission, Traffic Safety Advisory Committee. They're advisory bodies which can sometimes chime in on some of these applications, but they don't get to vote. The Township Committee is the one that enacts the zoning ordinances. They write the ordinances and they have to go through a specific process in order to adopt these ordinances. They have the 5 elected members. One of them is the mayor. And it's the zoning ordinance that regulate land use in the township. The ordinances are supposed to be consistent with the master plan. And as part of the adoption process for a new zoning ordinance, well, any ordinance that it's adopted goes through 2 readings. After the first reading for a zoning ordinance, it gets referred to the planning board. The planning board reviews it and says if it's consistent with the master plan or not. The township then has to vote again to adopt the ordinance. If it's consistent with the master plan, no problem. If it's inconsistent in any way with the master plan, they have to adopt a special resolution acknowledging that before they can enact the zoning law. Now, the zoning ordinances are the ones where one specifies how one can use land, what's allowed for buildings, heights, setbacks, size of buildings, and all of that. And you'll hear a little more about that from our engineering. And as I just said, the adoption procedure for this is to introduce it. It's usually prepared by a planner or together with the lawyer for the township, refer to the planning board, and then adopt it after a second hearing. These ordinances are combined and codified in Chapter 30 of the Township Ordinances. All the Township Ordinances are available to review on the Township website. In the case of Chapter 30, it's got 6 parts to it. The first part is titled Definitions, Administrative Provisions. Chapter 2, Article 3, Development Review Procedures, which talk about what the planning and zoning boards need to do. Zoning design and performance standards that are general across all zones. Article 5 is the actual zoning ordinances, which are specific to each zone. And then Article 6 is the environmental regulations. And last, it's considered part of the zoning ordinances, but it's published typically separately, is the zoning map. This in small is the zoning map for Holmdel. Different colors, as you see in the legend that you can't read at this scale, represent different districts. There's commercial districts, there's residential districts. The red one here, which stands out is red, is a medical district. The number of districts has grown over time, although there are rules and laws against spot zoning. You're supposed to zone a general area and not a particular spot. But for a variety of reasons, sometimes additional overlays have been created, for example, to create provisions for affordable housing. And the most recent ordinances the townships adopted have related to affordable housing. And you can see, if you find it online, and it is on the township website, you can blow it up and look at it a little bigger. More common zones that we deal with is R40. 40 stands for 40,000 square feet. It's a 1 acre residential. There's R40B, which is 2.5 acre residential. There's an R4, which is 4 acre residential. There's commercial, CO, industrial, and the like. The development types that we see can sort of be generalized to fall into 3 categories. Subdivision, that's if you have a larger property and want to divide it into 1 or more lots. And that has to go before one of the boards to get approved. A site plan. This is the layout of a lot, or exactly what you want to do where. Where's the building or structures going to be? Where's parking going to be? Driveways and the like. And a site plan is required for any commercial development or any change to a commercial development. And then we talk about bulk variances. This is where if you want to build a house on a lot, it's residential, say, but you want to do something that's slightly different from what's permitted by the ordinances. This may include intruding into one of the required setbacks. And if you aren't going to do that, you have to then get a variance from the board. The planning board reviews all subdivisions and site plans for permitted uses. So if it's a permitted use, you want to subdivide or do something commercial, it goes to the planning board, with a couple of exceptions that we'll get to. Planning board also is responsible for the development of the master plan. And the planning board, again, it's a 9-member board appointed by the mayor with staggered terms, like the zoning board. It's a little more complex makeup because the mayor is a member of the planning board or is designate. Another township committee member is required to be a member, a township official, and that's a funny category. And then there's 6 residents, they're called class 4, which have staggered 4-year terms, and there are also 2 alternates. The zoning board reviews subdivisions and site plans for if it's not a permitted use, or if the density and the floor area ratio don't meet the requirements for that zone. Conditional uses. There are, in every zone, the zoning ordinances spell out what uses are permitted and what's not permitted. In some zones, they're what are called conditional uses. That is, uses which seem to be good, but you may want to put additional requirements on them. And only if they meet those extra requirements does it become a permitted use. And if it doesn't, then it has to go to the zoning board. The conditional uses often say, for example, healthcare facilities or cell towers may be permitted in any zone, but with restrictions. The zoning board here's request for bulk variances, meaning exceptions or waivers from any of the side setback, front yard, how wide is the lot, how deep is the lot, what's the shape of the lot. When you apply for a building permit, the first step you do is go to the zoning officer. Is this a permitted thing? If the zoning officer says no, well, you can't do it. Although if you want to appeal the zoning officer's decision, then you come to the zoning board. As most of you are undoubtedly aware, by this time, the membership is appointed by the mayor, as all of us were. 7 residents, staggered 4-year terms, and 2 alternates with 2-year terms. As Marty referenced, the zoning board is quasi-judicial for the judge and the jury. And we can't have informal discussions. It's all got to be on the record. And we cannot prejudge an application. The application process has a lot to do with it. At the beginning of the application, if an applicant comes in, whether it's an individual or corporation or with someone with an attorney, they have to submit items that are on the development plan checklist. For a big application, this is a lengthy 10-page list. And Bob may make reference to it. The state also puts timelines on the processes that we go through. If an applicant submits an application and the board says, we don't care to listen to it, if the board doesn't formally act within a certain time period, it's approved. So the administrative officers are concerned about making sure that everything follows the right time scale. If you submit, say, only half of what's needed, and then the administrative officer with input from the engineer says it's not complete, you've left out half the things we want, it's deemed incomplete, then the clock doesn't start. The applicant has to resubmit whatever is needed so that it becomes a complete package. Once it is deemed complete, then another time clock starts on how much time the board has in order to do its decision. If the applicant feels certain of the things on the checklist aren't really needed, they can request waivers from the board, and the board would vote on that. And once certified as complete, the board's time clock to make a decision starts. A lot of this is all spelled out in the MLUL. Another thing the applicant has to do as part of this process that the board doesn't see, but all the expenses associated with processing an application, the cost for the professionals, the engineer, the planner, the attorney, are billed to an escrow account that is funded by the applicant. So the applicant has to put up funds ahead of time. If the account runs to zero, they have to put up more funds before the board will continue to hear the application. Decision process is, again, it's a formal process. The board will receive comments from the professionals and staff. Public hearings are held. All evidence must be presented at the hearing as part of the process. All discussions by board members with the applicant must be at the hearing. It's possible, depending on the nature of the application, an on-site visit may be held. There are special rules about that. For larger applications, the board engineer and the planner will prepare a review letter describing what their concerns with the application are. And you won't see that too much for small backyard applications. Written comments can be received from the Environmental Commission, fire official, traffic safety officer, and others. And if the board is not content with some of the information it's received, the board has the option to retain other professionals to review the application. And after all the testimony is done, the applicants can finish, professionals are finished, then the board has to make a decision in public and vote on it. As previously, as part of the hearing process, said it's a formal process. The applicant, like a court case, the applicant presents its case, the applicant witnesses, such as their professionals, testify. The board can cross-examine, i.e. question each witness. Then the public can ask questions of the witness. If there are objectors, they can present their case, the same sequence as for applicants. It's the applicant's responsibility to make their case. They have to justify the approvals that they're seeking. Public comments come at the end. As mentioned by Marty, he's our board attorney. He keeps notes about any agreements that are reached, and those become conditions which become part of the approval if granted. And the resolution of the decision of the board, it's memorialized by a written resolution. The one we had tonight was 7 pages. For a big application, it can be 15 or 20 pages. And then gets approved like we did earlier tonight on the one by the board. Only those who voted in favor of the decision may vote on the adoption of the resolution. And all the conditions are listed in that resolution. And those conditions must be met before building permits will be issued. References, I'll show you in a minute when I stop screen sharing what the MLUL looks like. We have some people that are involved in township staff in helping this process, and thanks several of them for joining us tonight. The zoning board secretary is Loretta. She should be, if you have board members have any question about anything going on, she's the first person to contact. Her boss, and also deemed the administrative officer, which means she's the one that can say, yes, it's complete or not. She's the one that reviews applicants after they're done. Have they met all the conditions? Is it okay to issue building permits? That's Bonnie, and she's also the planning board secretary. And Bonnie is somewhere here tonight. The zoning officer is Lonnie Lucina. She's joined us tonight as well. Thank you, Lonnie. She's the one that first reviews applications. Do they meet the zoning rules or not? A welcome also to Steve Winters. He's the director of the development department, which includes both the planning, zoning, environmental commission functions, but it also includes the construction officials. They're the ones that do the inspections while construction is taking place. Okay, I'm gonna stop sharing. Anyway, this is the Missing Land Use Law, my copy 2020. Bonnie will be arranging for the new people for them to get a copy. You know, it's a 1/2 inch thick, a lot of legal fine print. And it's where things like C variances, D variances, all of that are spelled out. Another book that I have is this one, a lot thicker, often referred to as the Cox Book. And in addition to the law itself, there's a long history of various legal cases that have taken place where courts, appellate courts, Supreme Court have issued decisions saying, here's how we interpret the law. And this tells you a lot of the history of the legal aspects of the law. You know, there's a lot of fine print in all of that. I mean, for example, one issue that came up just a few months ago was with regard to the makeup of the zoning board. Can a person be on the zoning board and on the school board at the same time? Well, there's a sentence in the law that says you can't be a certain kind of thing and also be on the zoning board. Well, can you be on the school board? But the Cox Book has a paragraph, more than a paragraph about all of this. And the courts have said that the school board is a separate entity from the township. So you can be on it. But the person we had said I could chose not to try to be on both boards at once. And then you'll find up in the offices in town hall, this is a bigger version of that zoning map where you can home in on, see, okay, this is where I live. That's an R40A zone, or this zone is R40B. And just what the rules are, and then look them up in the ordinances for that zone. Okay, so that's enough for me. Does anybody have any questions for right now on what I've covered before we go into Bob and some of the engineering aspects of the zoning process? Everybody's stunned. There's so much to deal with all of this.
Ralph, quick question. Is there a digital version of the MLUL? It would be a little bit easier to search things if you had an online version.
Bonnie or Loretta, do you know if that exists? If there's an online version? I mean, certainly all New Jersey laws are available somewhere online.
Right, when they get their book, Ralph, it'll give them those connections.
Okay, good.
It's part of receiving the book,
That's a
is that
great
you
point.
get that connection.
Maybe, Ralph, it's worth stating that for the new members, especially, I'm sure are overwhelmed. And you've already hopefully sat through that other class. A lot of this is going to be done for you, right? By our professionals. When you get review letters or the testimony at the hearing, you're going to know what's needed for approval. So taking the more complicated cases, you know, Kate or Bob will outline their aspects of the project. So you're not going to have to go searching for what kind of variance is this or things like that. I mean, for your edification, it's nice to know, but it's going to be laid out for you. And then the standards that are needed for the applicant to meet their burden. Kate always does a great job of laying that out in her letters if she does review letters or at the hearing. So you don't have to worry about not having that or memorizing it. It will be given to you in the application process, but it's just good to know where it comes from.
And during the process, if you feel there's some information you're missing, ask.
Correct.
Every question is legitimate. Okay, Bob? We're
Yes,
talking
sir.
about engineering.
All right, thank you. And welcome to the new board members. Yeah, Ralph and Marty had touched on basically all the administrative requirements for submitting an application for consideration by the board. So I'm just going to go into, and it'll be the Reader Digest version, otherwise we'll be here all night, of what I do as an engineer to inform the board of the requirements of not only the township ordinances, but the county and state, and if there's federal requirements that, you know, we bring that out. And Kate also brings that out in her review as a planner. So the first thing we do is, like Ralph had stated earlier, it's a completeness review. After the application is submitted to the township zoning board secretary, it's then logged in and assigned an application number, and then the application is distributed to the township professionals and staff for their reviews. The township does have, like Ralph had stated earlier, has adopted a development plan checklist, which outlines the engineering, technical, and administrative documents that need to be submitted for review. If the application is found to be incomplete, the applicant is notified by myself, and it outlines those items that need to be submitted in order for the application to be deemed complete. Once it is deemed complete, the board engineer notifies the board, and the applicant and the board secretary schedules a public hearing, as Ralph stated earlier. The review process, there's 4 types of reviews that occur. They're the legal review, the planning review, which Kate will go into more detail later. And then there's outside agency reviews, you know, such as the New Jersey Department of Environmental Protection, the New Jersey Department of Transportation, Freehold Soils Conservation District, county, the township police, fire, environmental commission, and if there's a water and sewer company, utility involved. Also, occasionally, like Ralph had said, the Board of Education would then be asked to submit a letter, especially if it's a major site plan or subdivision. And then comes the engineering review, which consists of several types of reviews. And I'll go into just the major type, which is a minor site plan or subdivision review. This is a review of a subdivision of property that only creates 2 lots. And then, excuse me, but it doesn't involve the development of any new streets or extension of any off-track improvements. Off-track improvements would be sanitary sewer, water, gas. And an example of that would be, like, you take a 200 by 200 foot lot and they want to subdivide it into 2 100 by 200 foot lots. And as long as it doesn't require any extensions, like I mentioned earlier, that would be classified as a minor subdivision. And then we would go into the major site plan and subdivisions, which Ralph touched on briefly. That's everything else. Everything that a minor subdivision wouldn't have to be reviewed by. So these reviews are the major subdivision reviews are they're very detailed, and we look at all aspects of engineering, and it's such as the location of the structure, the architecturals, the height of the structure, landscaping, site circulation, emergency vehicle circulation, grading of the site, ADA requirements, trash and recycling, stormwater management, which is a big issue, traffic impacts, the volumes of traffic, parking circulation. And we also, during the traffic, we will also make sure that we take into account counts that were before COVID, the last 2 years before COVID. So we get a somewhat of an accurate idea of what the traffic really would be. Environmental impacts, not only from the township, the county, and the state on these major subdivisions and site plans. We look at utility availability. We look at lighting of the site if it's a site plan. Survey of the property. Is there any buffers? Is there any encumbrances such as easements, utility easements? And an example, the board, and again, this is an example that was in the township that had a lot of these issues that needed to be addressed from an engineering standpoint. It's a corner lot. It had environmental issues, it's site plan issues, contaminated soils, and we had to look at all of that to make sure that it complied with all of the state, local, county requirements. And this particular application was located by a major stream, which which we had to really look at. The township environmental requirements, the DEP, wetlands, floodplain, flood hazard areas, letters of interpretation, what permits will be required. We had to look at the township stream corridor ordinances, the township conservation easements, the woodland retention, the preservation plan of the township, parking, loading, buffers, commercial to resident, what are the buffers between commercial and residential? I mean, this is a very detailed review, engineering wise, that needed to be done. And another example would be if it's a gas station, what type of fuel, and if it's going to be diesel, do you want to make it so, it all depends on the location, but do you want semi-tractor trailers coming in there? So we can restrict the type of flow nozzle that would come for just regular cars and, box trucks. And we look at delivery times. We would look at whether they wanted propane, air, vacuum, a kiosk, times of delivery of the product. And it all depends on the area that we're in. So it's a lot of items that that we try, that Kate and I try as the professionals, the engineer and the planner, to inform the board of all of these different issues that you need to know in order to make an informed decision as to whether or not you want to approve this type of development. Then we go into like minor grading plans. We had a application where the resident wanted to build a pool on steep slopes. And so we had to, I had to review it to see how this applicant wanted to build the pool into the steep slopes. And based on that, the board had made a decision to, approve this plan. But again, looking into all the different aspects that we have. And again, we would go into a corner lot where you have two frontages. And we'd have to inform the board of any of the setback requirements that would be necessary, or that so they could make an informed decision. That's basically it that's the Reader Digest version of what I have to do as the engineer. And I'm ready to answer any questions that the board members may have.
Just to add one comment, something you referenced indirectly and I didn't, but it's important that if the zoning board approves an application, the applicant isn't done. They have to meet all our conditions. But in addition to that, there are limits to what the authority of the zoning board has. We cannot overrule other bodies. Any other permits from other bodies, it's still the responsibility of the applicant. For example, wetlands, that's overseen by the state DEP. If there are wetlands on it, what is wet is determined, the applicant has to propose where they think the wetland is and where it stops, but the state DEP has to review that and agree.
Right, they have to verify.
They have to verify, and that's done with what's called an LOI, a letter of interpretation. And we've had more than one instance where the applicant said, I think it's here. And the state came, no, it's here. And that resulted in having to relocate or move the building or change the layout of the plan. So I always, if there is wetlands, I always look to see, let's get that LOI up front. So we don't review a plan that once the DEP gets it, becomes moot. It's a state highway, goes to Department of Transportation. The septic system, County Board of Health. We don't provide those reviews or approvals. So the applicant has to do all of that themselves.
No, that's correct. Yeah, it's incumbent on the applicant to prove his case as to why he should be approved for his application. All the burden of proof is on them. And we just review it to make sure that it complies with all, like I said, the state, county, and municipal land use requirements.
Any questions for Bob at this point? Again, Bob's always available. He does have other boards and tasks that he works on, but again, if you have any kind of engineering question, refer it to Bob.
Don't
Okay, I have a
hesitate.
question. I have
Don't
a
hesitate to
question.
call. Yes.
Sometimes we get, or I've seen it in the past, I don't want to reference anything, we give approvals on the condition that the conditions will be met.
That's correct.
Now, if the applicant does not fulfill one of those conditions, can the board take back their approval? Because we've already approved it.
Well, he doesn't have an approval until he complies with the resolution. And I think Marty can address that better than I can, but
It's probably better to say he has an approval, but it's subject to. And until Bonnie, the administrative officer, signs off on the last of the conditions, the applicant cannot proceed and get a building permit or do what they want to do. So if they do not fulfill it, or they just decide to sit on it and they just don't do anything, they can't build, right? So they do have to comply, or they can't do what we've approved. They can always come back and ask for relief of a condition. So if they determine, and it's very common that we do approve things subject to outside agency approvals, right? Whether it's DEP or Board of Health or whatever it is.
Right.
If that happens and they come back, they go and they figure out the DEP, let's use Ralph's example for wetlands. No, the LOI determined the line is different than they thought. That creates a setback issue. They have to come back to us for additional relief, either an amended site plan or an additional variance or a greater variance, depending on what the circumstances. And in that case, that we would open it up and we would hear it just like a regular application, but it would probably be limited to that one issue. And then we would, decide again, another vote. And if we approve that, then they can move forward again. If not, they can't move forward.
So then in essence, the lack of issuance of the building permit would be the thing that to prevent that applicant from going further, even though they got approved.
Correct.
correct.
Yes.
That's right. In fact, I would have to sign the plan to say that it's okay, that it is compliant from an engineering standpoint. Then the board chairman and the board secretary have to sign those plans as well. And then we can give it to the administrative officer, we can give it to Bonnie, we can give it to Steve, and then they can determine whether or not they'll issue the permits for them to construct. But there are checkpoints and safeguards that, like you said, if they don't do what they're supposed to do, can they still build it? No, they can't.
Bonnie has a process that she goes through, and when all the conditions have been met, she creates a formal letter acknowledging the conditions are met, and that gets sent to Steve. And only after that's received will he, and that they, not necessarily just himself, but that department issue any construction permits.
Okay.
But once we approve the resolution, we're no longer involved. So the board members are no longer involved. If you hear scuttlebutt that something happening, somebody asks you a question about, there's no involvement of the board anymore. We have no authority to override the administrative officer and say, oh, that well, that's met, or let's waive that, or whatever, unless it comes back to us as a formal request.
Any other questions at this point?
I have a question about the storm 100-year storm, etc. With global warming, it seems like the storms are getting worse. Is what we have now going to change in the future?
The state Environmental Protection Agency, as early as March 2nd of this year, revised all of their stormwater management requirements for water quality and issues that you just brought up. So there's a whole new set of rules on how we review stormwater management.
For 2021, right, Bob? 2021.
Yes.
Yeah.
Yes, March of last year, I'm sorry, but so that's how, and so I have a whole different requirement now on how I review detention basins, underground detention systems, and general stormwater management for the area that this application is in.
One of the things with the new rules is they're extensive, but also it requires green infrastructure. You have to use best management practices, infiltration, and not just push the water somewhere else.
And water quality too.
All of the above.
Right.
The state also required, consistent with that the township adopt some new rules consistent with the state rules. And there's, I don't know, tens of pages or hundreds of pages on the
More about
details of
100.
all of this. Yeah.
And
That's
Gene,
why we have
very,
professionals.
it's very technical, and a lot of us as board members, as lay people don't understand some of it, which is why when you come to stormwater specifically, if you have questions, obviously ask them. But Bob will give an opinion whether he believes the applicant has met the requirements, as well as the applicant's engineer. And at that point, if you just don't like the concept, you need to be careful how your questions are, how you make a determination of an application, because we don't want Bob saying they met the requirements and then we say, we just think it's going to flood or whatever, without tying that into safety or some other issue that's a legitimate issue to talk about. So when we get to those things, we can talk. You can always talk to Bob, as Ralph said many times, any one of us independently, myself, or the chair. But I would reach out at that point. And, if you have concerns of a specific application on a technical requirement, I would probably reach out and understand the process better in case you don't, and then know where to focus your questions in the public hearing.
That's correct. And like I said, like Ralph said, I'm available anytime. You have my contact information. I don't mind phone calls, after hours. So, don't hesitate if you really need to have a question answered.
Yeah, you can't simply say, I don't like this application.
Right.
That would be immediate grounds for appealing the decision, going to court, and saying this was arbitrary and capricious. The judge will look at what's the evidence on the record. Was there adequate testimony given to say, yes, it won't flood, it will flood? Did the board's engineer agree? Are there other experts? Was there traffic experts as to how much traffic is there going to create traffic jams all over town, or what? And those are all technical things. And as I said it before, if we're not satisfied with the level of information we've gotten, we have every right to seek out other experts or bring in anyone or whatever to make sure that the record reflects accurately all the technical details. So that if you're saying, no, it doesn't meet the requirements, that there's a very specific set of data that supports that. Any other questions? Let's move on to Kate, our planner.
Excuse me, Ralph, there is a question from the public.
Well, let's finish the presentations and then if there's time permitted at the end, I'll allow public to ask questions.
Okay.
Hey, just so you know, Ralph, it's based on the misunderstanding that Bob said the new stormwater regulations were taking effect this year, but he clarified they've taken effect already last year. So I think he actually answered the question by his comments before.
Right, and the township did adopt a new stormwater ordinances into the zoning ordinance. They may not have done it in March. It may have not been till April. Okay.
Yeah, okay. Hi, can I share my screen if I don't have to if we're not available?
Sure, we can.
Kate, hold on, let me make you wait.
Okay, great. I wasn't sure who was handling it. Thanks, Loretta.
You do this, why is she, I don't have a choice to make her a co-host.
I'll take care of it, Loretta. Done.
Oh, okay, thank you, Brian.
Thanks, Brian.
I don't know why I wasn't able to do that. That's weird.
Okay, so just we're getting this ready to the new board members. Hi, welcome to the board. My name is Kate Keller. I'm the board planner. My firm is called Phillips Price Greigel Laney Hughes, and we do serve as consultants to the board in a same capacity that Bob serves as the engineer. We do serve as the board planner. And so, you know, our role in general is it's less technical in many ways than Bob's is, with a lot of the coordination with outside agencies, but we get the plans as soon as they come in. We look at them for both, you know, sometimes for completeness, but also we do thorough reviews once they're ready to go in. So at every hearing, except for the smallest type of you know, residential backyard variances, I don't do a report for those, but if there's something does get a little more complicated, where in some cases, you know, they might need certain types of variance, but for most of the larger non-residential or non-single family residential applications, you will always have a report from me. So let me I put together a presentation that's pretty simple, but I just want to, I think that seeing a lot of this like written out might be, at least for now, while I go through it, might be kind of helpful, because there's a lot of, I would say, kind of like words that come up a lot in hearings. And so I just want to kind of point these out. So I'm just going to do this full screen mode. So I think that, you know, Ralph gave a pretty good overview of the municipal land use law and how that really forms the basis for everything. Oops. Been a while since I did this, how that really forms the basis for what the board's powers are. So just to talk about the two types of variances that you do see before the board, and I'm going to go into more detail here, but variance is literally defined at section 7 of the MLUL as the permission to depart from the literal requirements of a zoning ordinance. So what you'll see in almost all cases is that while this is like a state enabling law that grants the power to zone, almost all ordinances are determined by the township. And so these are from the township's ordinance in particular, but statewide, there is a formal statutory criteria to do that. So the two types of variances, just in general, which I will get into more detail, are D variances, which are generally things that have to do with the use of a property, or sort of a more, what's been determined to be like a more major physical improvement, which might have to do with density or a much higher height, et cetera. And then the second would be a C variance, which is often known as the bulk variance. And that ranges from everything from the location of a pool or a shed on a single family residential property to, you know, the number of parking spaces in a major commercial development. So the one thing that when an applicant does come before the board, and this, you know, this variance testimony will be put on by, usually what will happen is that the applicant will put either their engineer up and kind of set the stage for the property, the stage for the application overall. They'll have their traffic engineer, they'll have their architect. And then when there is a case where there is going to be a planner needed, the planner usually goes last. So you will have had almost all the information, you know, hopefully that you will need to make this decision based on this criteria by the time that this planning testimony is put on. So for all types of variances, positive and negative criteria have to be set forth by the applicant, and it's up to the board to determine on how these are met. So the positive criteria is dependent on the particular type of variance, which I'll go into the next few slides. Negative criteria is the same for each variance. And these are phrases that you will hear a lot, which is that the applicant has to show that there will be no substantial detriment to the public good and no substantial impairment to the intent and purpose of the zone plan, which is really, the zoning map, the master plan, et cetera, and the zoning ordinance.
Excuse me, Kate,
Yes.
are you going through some slides?
I'm not yet, no.
Oh, okay, because you referred to a slide, and all I'm seeing is the title so far.
Oh, wait, whoops, I might have had the wrong one up there. That's actually an older one from my firm, so I apologize for that. You are going to be seeing the right one now.
Yeah, okay, that's what I was thought you were.
Yes, okay, I'm sorry about that. I moved it to my other thing. Yes, okay. So no, Paul Greigel of my firm did inspire this one, but I'd have created a new one that has some of the more updated things. So I apologize for that. Thank you, Ralph. So yes, so everything, I'm going to go into it a little more, but this is really just the basics of what we've been talking about here. So just a quick overview of the C variances. The board has the power to grant what's called C1 or hardship variances, or C2 or flexible C, which offers the better zoning alternative. So I think that, the word hardship gets brought up a lot at meetings, and I think, we're going to go into how that does have really a specific definition by statute. So these are variances that can be granted by the Board of Adjustment, either within or outside of the context of a site plan or subdivision application, depending on the type of application that's involved. Same for the planning board as well. And the approval for these variances requires only a simple majority of the board. So that's if you do have, for example, a backyard variance, you'll need, if there's 6 members on the board, you will need the vote of 4 positives in order to grant this type of variance. If there is a D variance associated with it too, that's a different type of approval, but just for C in general is just for the simple majority. So in this case, the C1, or what's otherwise known as the hardship variance, this is really where it comes down to, it would result in particular exceptional practical difficulties or hardship upon the application. And these are really due to physical qualities of the property, where it's exceptional narrowness, shallowness, shape, topography, extraordinary exceptional situations. So just as an example here, this might happen if someone is requesting a variance for the location of their house or the location of a certain feature on a site. And one of the pieces of testimony they might put up about that is that, for example, there's a stream in the rear of the property, and in order to get a significant amount of buffer from the stream, they have to do this in this certain way, to put it in this certain location. Sometimes this has to do with properties that have 2 or even 3 different front yards because they are at a street intersection in that manner. So these are all just examples of reasons that you would think that an applicant met the burden of a hardship variance. In terms of the C2 variance, is also known as the flexible C, and that's really what it is. And it's really meant to show that this represents a better zoning alternative, and the board has to make that determination. Whereas the purposes of zoning would be advanced, and that's a component in the municipal land use law, and that has to do with much what Ralph talked about earlier, where the purposes of zoning in the MLUL incorporate everything from promoting health, safety, and general welfare to contributing to the appropriate location of different uses in different areas. And again, this is something where the applicant will either put it on the record or you'll otherwise, either I might mention it, but it's not something that you would be expected to fully, to know offhand, because again, that it would be the applicant's burden to prove that. And then they also have to show that the benefit of deviating from the ordinance would outweigh any detriments. And this is all part of this, where show it really benefits the community and not just the applicant in that sense. So now I'm just going to move on to the D variances. And this is really what sets the zoning board apart from the planning board, is that the zoning board has sole jurisdiction over any case, no matter what type of application it is otherwise, that requires a D variance. So again, positive criteria here is that the D variance can only be granted in particular cases and for special reasons. That is also dependent on the variance type, which I will go through shortly. And then again, the same negative criteria applies to the D variances. And there is case law, which I'm going to address briefly for each of these, that you may hear, and by case law, this is, with the Superior Court decisions that have been shared with different ways that have really set these statutes in addition to the municipal land use law. Here, I just also said much of this zoning board has sole jurisdiction, has to have a public hearing, and the approval requires a minimum of 5 yes votes, 5 affirmative votes. So one thing that may happen is that in a case where some say, and this is one of the reasons we try to schedule meetings when people, everyone can go, if only 6 board members can make it to a meeting, an applicant for a D variance can say, I don't, they can choose to not have a vote taken that night because there is not a full board present. So it does require the minimum of 5 votes. Just going to run through the types of D variances, and people hear D1. D1 is really just what's generally just called a use variance. That's because that's to permit a principal structure, principal use that is not otherwise permitted in the zone. D2 has to do with the expansion of a non-conforming use. D3 is a variation from the ordinance's conditional use standards. D4 has to do with floor area ratio, which is exceeding the set floor area ratio that's required by the ordinance. D5 is similar for density, and D6 has to do with height, which is exceeding the ordinance requirement by either 10 feet or 10%. The most common, all of these types of variances do come before this board and almost every board at different times. D1 is going to be the most common. We've also seen D3 variances, and then I believe there's a D4 variance that has been submitted and will be coming up. So the first 3 are slightly different, and then the final 3 here. I'll address those very briefly because the standard of proof for those is pretty similar for each. So the D1, this is just, kind of the big one, I guess people would often think, because it really does have the highest standard of proof. And this is really, if something is not permitted in the district, then it's not allowed, and they have to get a D1 use variance. So I'm just going to touch on the fact that there are really two separate categories for D1 variances. The first is what is called an inherently beneficial use. And this is defined both in the municipal land use law text itself, and it also other definitions have been set forth by the case law. And it's a use that advances the public good by its very nature. This can be a hospital, a house of worship, a school, or a senior living facility, including assisted living or a nursing home, et cetera. And because it's been deemed an inherently beneficial use, then the courts have recognized that automatically meets the positive criteria, which is the special reasons that are required to grant the variance. But that's not where the board's responsibility, or where the board's review of the application ends. The courts have also established what's called a balancing test. The case is called Sika versus Wall Township. And it sets forth really the framework for an inherently beneficial use, where a board can look at both the fact that it's deemed to be inherently beneficial and meets the positive criteria, but also to make sure that it does fall within, the standards of the ordinance otherwise and what's appropriate for the town at a given site. So it's really identifying the public interest at stake and how use rates on such a scale. Like, for example, there is one case from about 10 years ago, I think, where a project that was going to provide 2 affordable housing units, and that was at just 2 units, not a larger development. This was in South Jersey somewhere. The courts overturned, or they overturned the appeal, which was basically to say that because it was only providing 2 units. That wasn't enough to compensate on the scale of the public interest for all of the other board's other problems, which included like the scale of the dwelling and it in general. So that was called salt and light. But yeah, that's just one example of where the board does have some, there is a lot of as long as you're within this framework, there's a lot of opportunity for review. And also looking at any detrimental effects that will ensue from the grant of the variance. And then the third step is looking at whether any reasonable conditions can be imposed here, which has, this can be like, can the applicant mitigate what's going on here, but if they add more of a tree buffer, it can anything like different ways things can be mitigated, and that can range from something like a tree buffer. Other cases it might involve going from 5 stories to 4 stories, etc. And then the final step here is that to weigh the positive and negative criteria to determine whether it would cause substantial detriment to the public good. And that's really just the crux here, is that the negative criteria always has to be addressed. So that's an inherently beneficial use, and that's those small percentage of uses, but it does have a special way to handle it. So the other thing for a use is not inherently beneficial, which again is anything that has not been included in the MLUL or a case law, saying that they do have to set forth these special reasons that promote the purposes of zoning, and additionally, the site have to show that the site is particularly suited for the proposed use. And this is a little tricky because they have to show that this is the only site that's particularly suited for the proposed use, but they do have to, satisfy, they have to address that to the satisfaction of the board. And in that case, hardship can be a justification. Fiscal benefits to the applicant cannot be. Then in addition to the negative criteria, they also have to set forth what's called the enhanced quality of proof, this is a case called Medici, which also comes up a lot, which they have to demonstrate that the granting of the use variance is not inconsistent with the intent and purpose of the master plan and zoning ordinance. And so one of the things that happens here is, say a use isn't permitted in the zoning ordinance, a master plan amendment or something of that nature was approved maybe 10 years ago, and and the township decided not to include it then. The applicant can say, well, here's the list of circumstances that have changed since then, and that here's why it's not consistent. So that's one example of how that can be brought up by the applicant's planner. Excuse me. So another one that comes up fairly frequently is the D2 variance, which is the expansion of a non-conforming use. This is really has to do with any use that would not be permitted in a zone if it was built today, but was there prior to the implementation of the current zoning. And so this is really anything that increases the intensity of the use, which is enlarging the building, actually even making the property smaller, putting an addition onto it, anything like that. So they do have to advance special reasons for that too. And it can be improving the existing conditions, making it generally more contextual in its setting. And that was in a case called Burbridge versus Mine Hill. You don't need to justify the use that's already there. You don't have to reconcile the enhanced quality of proof. So this is where basically the burden of proof for the board does start to go down a little bit here, but they do have to address the negative criteria. D3 variance has to do with deviation from a specification pertaining to a conditional use, which Ralph mentioned earlier is a type of use that is permitted by the ordinance, but only in cases where it meets certain conditions. So, and that can be, you're permitted to have this type of building, but it can only be this high or this, but they're higher, and because it's more, it carries more weight than a typical zoning ordinance because it is related to a specific use and not just for a specific zone. So because the use has already been contemplated for the zone, they don't need to prove it's appropriate in the zone, but they have to show that it could accommodate any problems associated with the use, even though it doesn't comply with all the conditions. Like, for example, if the lot size is smaller than the conditional use standards say, an applicant would have to come in, the burden of proof would really be, how are you going to accommodate this property on a 3-acre lot when our ordinance requires a 5-acre lot? And that could really address all kinds of conditional use standards. Once again, got to address that negative criteria as well. So then here's some variances that are often less common, but these are also kind of all related because they deal with really the physical nature of a building, which rather than the use that's not being permitted in the zone. So these are all variances that come before the zoning board, even though not in all cases, but in many cases, the use is fully permitted in the zone. But the way that the MLUL is written, it is really saying that these are type of variances that make such a difference in the physical nature of the building or that they rise to the level of a zoning board approval rather than a simple site plan or planning board approval. So this is to deforest permitted increase in floor area ratio, which is defined in the ordinance and in the MLUL, which is really basically the square footage of the building divided by the size of the property, and where the township's ordinance sets maximum requirements for that in different zones. And those come forward in both commercial and residential development. For example, a home that's on a smaller lot that maybe was built, in past decades, and they want to put on an addition there, but basically the zoning doesn't always keep up with conditions. And that's one of the ways that an applicant would justify that. A D5 variance is to permit an increase in the overall density of the development. It's not have to do with the lot area, it doesn't have to do with the size of the dwelling, but this can be, for example, in if it was a multifamily zone or something like that, if you want to put a 3-unit building, even because it's anything above 2 dwelling units, but say you want to put a 4-unit apartment building where 3 was permitted. That's not an example that exists in Holmdel, but it can also have to do with the basically units per acre that the ordinance sets forth. And then a D6 variance is again, that's the height. So it's either anything that exceeds the height by either 10% or 10 feet, whichever is greater. So in a residential zone or actually many of the zones in the township, where say the height is the permitted maximum height is 35 feet, it rises to the level of a D6 variance if that height is anything over 3.5 feet higher than that. So that's 38.5 feet. They would have to come to the zoning board. And these are similar to the previous case law that I mentioned, which is that it has to show how it can accommodate any of these individual qualities for the site. So if this is a property where the floor area ratio is higher, how can the building, what's the site design, how can the building design accommodate that in a way that will not have negative impacts on the surrounding area and won't substantially impair the zone plan and zoning ordinance. So these are a couple of different case law for height that you will see, which is, for all of these different kind of physical variances. And then just briefly, this is my last item here. These are the other 2 powers of the zoning board of adjustment, in addition to variances and site plans, et cetera, which I believe were also mentioned at the top of the presentation. But first is the appeal of a administrative officer's decision. This has to do with either the zoning officer's decision, having to, whether you might say that a use is not permitted, and so then the applicant, whoever had applied for that zoning ordinance, can appeal to the board and say that I think that this determination was incorrect. That doesn't have, these are relatively infrequent. But the second one, in the interpretation of a zoning map or ordinance, is a little different. It's similar but different. But that's where, if say the same thing happened where someone thinks their use is permitted and they don't like the answer they got, or even before they get that answer, they can come to the zoning board and say, I would like you to interpret what this ordinance means. And that's, again, that's something we'll help you out with as your board planner, but these are relatively, these are less common in general, I would say. So, oops, I did a little typo there, apologize for that. So that's really you know, and obviously as much as, you know, these are a lot of information tonight, but I was just hoping to just kind of run through a lot of the terms you might hear as a zoning board member. And again, you know, a lot of the case law, anything like that I mentioned, will usually be in either my report or, you know, at the hearing itself, myself, or, well, you know, I may speak to or ask questions of the board's planner, and you can, or excuse me, of the applicant's planner, and you can always feel free to ask me questions either upon receiving the letter or at the hearing. So if in the cases where these different proofs do apply, because again, you know, I'm here to help you as the board make these determinations and make these interpretations. So, you know, just always happy to give anyone guidance as they need it.
Thank you, Kate. I mean, this is a different aspect of what the zoning board does that people are not often, who haven't been involved with this process, not familiar with it. It's what's the rationale for saying yes or no, and to do so in a legal way, consistent with the laws and what the state has set out. And, you know, backing up one little bit on some of this variance business, that having been involved with writing some zoning ordinances, it is impossible to write the perfect ordinance, which takes every possible consideration into account. Can't do it. So that the state has provided the flexibility of having a zoning board and a planning board to provide some human beings to review the application and say, does this make sense? Does this meet our criteria? And in the details of the criteria and what considers appropriate proof is where we come back to Kate. Does this meet the history of what the law says and what the case history says is appropriate or not? So with that, any questions about, and it's why we have a planner and why every board has a planner, because to help interpret the law and the history of the law to decide what is appropriate for Holmdel. Is this meet all the positive criteria? Is there negative? What's the right balance for each particular application, to be fair to the applicant and Holmdel? Any questions on anything for tonight?
Just one thing. Is it possible to get the few graphs that are presented sent to us by email or whatever?
Yeah,
Sure.
absolutely. Yeah, absolutely.
Yeah. I guess, Kate, and I'll send mine. I think I'll have to see if I've updated and send it again to Loretta.
Okay.
Send it to Loretta and then she can send it out to everybody.
No problem.
I did see one hand raised with regard to the stormwater rule question. And the state stormwater rules went into effect March 2nd, 2021. And Bob, I believe that applied to any development was deemed complete prior to that date.
Yes, if you were deemed complete before March 2nd of 2021, you did not have to comply with the new stormwater regs.
Right. But if
All right,
it came
anything-
later, you do. Any application that was not complete at that point in time has to meet the new rules.
Correct.
In that was one question from one of the public participants. Do any board members have any other questions on any of this material that we've covered tonight? I'll just reiterate again, if thoughts come to you at another time, please don't hesitate to contact Kate, Bob, myself. And now with that, we'll move into Marty, wants to advise us about legal matters to keep us out of court.
Ralph, is this where you want me to do the test now to make sure everyone's paying attention?
Sure.
So you've heard a lot of it will come to you during the hearings. It will be explained to you. Don't worry about what you've heard or didn't, what you think you may have missed. Again, as Ralph has said many times, Bob and Kate are good sources. Any questions, you can always call me. You can call Ralph, has a lot of experience. Dimitri's been a former chair. He's had a lot of experience. Valerie has been a former chair. So you have former members, current members, I mean, that have a wealth of experience. Again, those discussions, if you have a question, need to be one-on-one. They can't be in a group setting. Just reiterated what I said earlier. So my role is to protect the integrity of our decision, whatever that may be, approval or denial. And what we don't want to do is we don't want to get overturned if whatever our decision is, but at least we want a court to know that our decision was made in good faith. It was not arbitrary or capricious or unreasonable. That's the standard that's used. And my role is to hopefully get us there during the discussions of the comments that lead to a vote. So you're going to see a lot of what you're going to hear is engineering let's take a typical big D variance application. It's going to be a lot of engineering. It may take multiple hearings. And then the planning will come toward the end, as Kate has said, and a lot of that really gets to the standard that we need to see whether the applicant met their burden or not. So, and Kate will have that in her review letter. There will be a review letter on a big application, and we will be talking about it. It's important for the board members, either through the comments or at the end when there's a discussion of a resolution, an approval or non-approval, to put their reasons on the record. They don't have to repeat the same thing someone else has said, just saying I agree with a formal comment, but it's important to get the comments out there. So if we believe the applicant's planner was credible and their engineer was credible, and most likely if that's the case, our professionals will probably be in agreement. And if they're asked, they may say that they don't see anything wrong with their testimony, or they may have slightly different comments, but you're going to hear all that. And it's up to us to say whether we believe that testimony was credible. And if it was, every applicant has the right to come before us to ask for relief, right? No matter how crazy we think the application is, to simply say it's not in the ordinance, we're not going to approve this. That is unreasonable. So it's important to listen to the testimony, and to make those findings publicly, which we can then memorialize in a resolution and vote on subsequent to the actual vote of the hearing, of the approval itself. Probably more important in denial, and more important if it's a contested application, because most likely one of those may result in court. If there's no objectors and there's no audience members, the chances are that go into court are less likely, but nevertheless, we still want to have a defensible position, and we want to have a resolution that has merit, right? We do not want to pass something that lacks merit, because that's going to get slapped down very quickly and make us look bad as a board. So again, my role is to protect the board. If I see that comments are not focusing in on the standards that we need, besides Kate and Bob jumping in, or one of our members that has experience, I would do the same. So as an example, if there's take a backyard variance, it's a very narrow lot. Clearly, whatever the addition is can't fit in the setbacks. There's some uniqueness to that property that almost is impliedly a hardship, right? Even if the applicant comes without a planner, because you'll see a lot of our neighbors come for simple applications. Backyard variances is the most common one, and they don't have a planner, they don't have an attorney, they don't have an engineer, for the most part, and they don't know the ins and outs of these processes like their professionals would if they had them. So you might hear Kate ask a question of the applicant. Well, would you agree that if we approve this, it would not have an impact, a negative impact on your neighbors, or a question along those lines, to get them to acknowledge that there is no negative impact. Some of that can be inferred, but it's better when they say it publicly. And then, the board would vote on that. Now, for the board to say, well, I just don't like the style of your house, it's too modern, that's not a good reason to deny an application. Right? You need to find that you do not believe that there's a hardship, right? You got to get to one of the criteria elements, whether it be the positive or the negative. And, whether the applicant likes it or not, that would be a valid then discussion, assuming that was backed up by some of the testimony that we've heard. So again, focus on the criteria that's needed for approval, and making sure that we enunciate some of those criteria as we discuss the application. That's all going to happen at the end, but even our comments during the hearing itself, they're important, because if we're talking about, if there's if the planner makes a comment and you have a question at that time, and then that leads to a comment, that happens to be a hearing prior to the hearing that we vote. That's an important comment. Get it out when you think of it. I'd make notes. I try to take some pretty detailed notes of the hearings. You'll see I'm looking down a lot. I'm not, especially these Zoom meetings, I may not be looking into the camera, probably most of the meeting, because I'm taking very detailed notes, but I will try to reiterate those reasons in our resolution, because we need to specify what they are in order to have, again, a credible resolution. The other aspect of the resolution is making sure I capture all the conditions. And the conditions, you're going to find a lot of them have to do with, the engineering aspect of it. So when Bob's testimony, he may say, some things are not met, and a lot of that's a lot of give and take back and forth with the board. And a big one that comes up is landscaping. Maybe add more landscaping in the buffer, or whatever the issue is. And if the applicant's willing to give, and then you'll find that Bob may say, I think that's a reasonable response. Now, we don't have to agree with either one of those, but at least that the applicant's trying. Our professional believes that they've made an effort and can do an adequate job. That gives us reason to say, okay, well, it has nothing to do with hardship per se, but in fact, they've given us a condition, they've given us some additional landscaping, and that may, you may find then that the positive criteria have been met. And if they don't, if there's an applicant that's just obstinate and says, I don't want to give you anything else, and they haven't, especially if Kate's not on board with the positive and negative criteria, you'll probably find that there's going to be a denial that they have not met their burden of proof. But going back, when we start the hearings, again, everyone has a right to the hearing, so we don't want to prejudge a hearing. We do not want to, when you get an application package from Loretta, you don't want to start posting on social media. I can't believe, whatever it is coming in, Wawa wants to come in and put a, new gas station right down in Holmdel Village, and making up something, obviously, but, you don't want to prejudge anything. And you definitely don't want to do it in a way that's going to be discoverable by the applicant. So social media, emails, discussions beyond one-on-one with members, Bob, Kate, myself, or any of the other members one-on-one. We will ask at the beginning of the hearing also if anyone has a conflict, especially on the bigger applications. If we forget, it's still incumbent on the board members, if they know that there's a conflict with the applicant or the applicant's professionals or anything like that, to recuse themselves. So the municipal land use law goes into detail of what is a conflict. There's also conflict law in the common law itself, just based on the law that has evolved over the years. And there's also an ethics law that applies to all of us. And all three of them have similar, but they're not identical language on what's a conflict. I have a little summary that we can share with everyone if it's helpful, and Loretta can send that out to everybody. But if you believe you have a conflict, you probably do. Is the bottom line. So, or it can be a family member too, right? So it doesn't, if somebody's spouse is employee of Wawa in my prior example, there's a conflict there, and you need to recuse yourself. We don't want to do is have that come out later on in the hearing, because it could really, the whole hearing could be void. If there's been even participation by a board member, even if they don't vote at the end of the day. So you recuse yourself, you need to leave the room or leave the meeting and not participate at all, because we don't want you to influence other board members, with a touching your nose or whatever signal you give them. So that's important also to make sure, and we'll remind you when we start. And again, if you think you have a conflict, you probably do, but always call me if you have any questions at all, and we can go over it ahead of time. We've had it a couple times, and a couple times at the end of the day, it's your decision. We've had some where the board members have stepped aside, and some where they've said they do not believe they have a conflict. So it could go either way, but just keep that in the back of your mind too as we go forward on these applications. Sometimes you'll find that when you get an application, you might find, oh, that's my neighbor. Not an immediate neighbor where you may have a conflict, but it's in my neighborhood somewhere, or my old neighborhood, let's say. And you may just drive by. You may even try to walk the site. So you don't want to make a decision while you have the ability to know the site, and you have the ability to drive around town, and you actually have the ability to know what certain conditions are based on the fact that you live in this town. Any decision we make needs to be on the facts that are given to us at the hearing. So if you were to be familiar with the site and you just vote no at the end of the day, without saying why, that's not a defensible position. So you need to be able to you actually should put your knowledge of the site on the record, let the applicant have a chance to cross-examine you, and or let other board members chime in, and that will lead to a discussion. And ultimately, you may find that there was a misunderstanding on your part, or in fact, you may enlighten other board members, but it needs to get on the record, and it needs to be at the public hearing so it can be discussed, and you can be cross-examined. I mean, it's, if there's objectors, they have the right to speak, but in fact, the board has a right and the applicant has a right to cross-examine objectors as well, because again, sometimes, a certain position may not have all the facts, and by that back and forth process, the board itself can come to a conclusion who's more credible, the objector or the applicant, or the objector's planner or our planner, the applicant's planner. And at the end of the day, that's what's most critical. We are quasi-judicial, so we're like 7 judges sitting up there, but yet we're not. We have the flexibility to be reasonable. I always say these are our neighbors for the most part. I'm not talking about the big applicants that are the big outside corporations, but especially the backyards. These are our neighbors for the most part. We should treat all applicants with respect, all objectors with respect. But especially when it's a non-represented applicant, sometimes you may infer that they made the standard, like a hardship, for instance, just because they just don't know the process. And Kate will try to, she'll try to elicit some of that from them as well. And we just need to be mindful of that, not just say, oh, you didn't come with an attorney, and I didn't hear you put all the criteria on the record specifically, therefore I'm denying it. I mean, it doesn't really work that way. And we have the flexibility to make findings based on who's before us and kind of what the testimony has been. When that process is done, there'll be a vote. As Kate went over what was needed, a simple majority for C variance. We need 5 yes votes for a use variance. If it's approved or denied, my main action starts at that point behind the scenes. I will do a resolution. That resolution will get circulated to all the board members for comment, as well as, again, the applicant's attorney, if there's one. At some point, when there's final comments made, there'll be a vote like there was tonight. And again, all the eligible voters will be called out by Loretta, and there'll be a vote. Generally, that's just a pro forma kind of situation at that point. And all you need is a simple majority on the resolution to approve it. Generally, you don't really deny a resolution once it gets that far, unless there's facts missing in it that you deem should be in there that were on the record that just never got in. I've never seen that, but that would be really the only example why probably be any discussion on the resolution, and that would probably be done prior to the hearing itself. We would make sure that gets in if something really was missed. At that point, the applicant has a 45, they have to publish a resolution, and there's 45 days they have to run to make it unappealable. And during that 45 days, any objector, anybody can file an appeal, and they can try to seek to overturn it in the courts. And again, that's where the strength of our resolution is important. If we ever get to a court, that we don't want a judge saying, you just regurgitated the case without putting any facts in there. And it doesn't show that the board had any discussion at all on the merits of the positive or negative criteria. And that's all beyond us, but that's what happens. That's my involvement, and we do. And my goal is to protect the integrity of this board and the members that are on it. So some attorneys, in some boards, they actually try to take more control over meeting. Some obviously their role, they believe, is to advise, and that's I fall in the latter category. So you'll see me whisper to Ralph or whoever's in the chair at that time, and give my 2 cents if something's going in a way that we think we need to bring it back. If somebody's talking about things that are not relevant at the moment, again, one of the board members may say it's not an appropriate comment at that point, and or I may just say it out loud as well. But typically, I would probably try to defer through Ralph to make and because the chair controls the meeting really at the end of the day. So while any board member can ask a question at any time, if there's procedure issues, we typically want to funnel it all through the chair and let the chair try to run the meeting and make the rules with the applicant and the objectors. Because if there's a lot of objectors, we just can't have everybody just asking questions at any time they want. Typically, we want the applicant to finish its presentation, at least a component of its presentation, like the engineering component, and then have our professional give their testimony. And then the board would ask questions through this whole process. And then, we may open it up to the public to ask questions on that engineering aspect only, saving public comments generally for the end of the whole application. That usually comes at the very end when people say why they like something or they do not like something. And again, that process, if you see somebody's kind of going far afield, just say something. Even in the public hearing, you can say, Mr. Chair, or to myself, I think, maybe this is not appropriate now. Maybe we should be doing this later on, and we can all decide at that point. But I started saying we're quasi judicial. We do have flexibility, so we don't want to be this hard and fast body that has no sympathy for an applicant. I don't think any member that I've worked with over the 13 years on the planning board and 6 on the zoning board have been that way, but we don't want to be that way either. I think it's important that we show the respect to our applicant and the members of the public that spend the time to show up and be part of what we do. I am available anytime. I've sat with people, come to my office or go to lunch with members over the years. So if anybody thinks they need more information, I'd be more than happy to do that. And it's just knowledge of the process never hurts. So if there's a specific application that involves a very specific kind of variance, and you're not 100% sure what you should be looking at or focusing in on, again, reach out. And whether we do that over lunch or a 5-minute phone call or with the chair or any of the other professionals, I would suggest you do it. Don't just keep that concern inside and then it doesn't come out, and then there's a vote that maybe doesn't go the way that you want it. We do have very good staff as well, right? So Loretta knows what she's doing. She runs a lot of these, especially the backyard variances. She deals with those applicants all the time from start to finish. Bonnie oversees her and she knows everything about zoning, although she's more focused on the planning board. So if you have a question, call Loretta about, if you didn't get something or you're looking for a piece of paper or timing. If she's not available, you could ask Bonnie. You can always try for Steve. I don't want to burn Steve with any of our calls, but at the end of the day, you could ask him and he could look into it as well for you. But generally speaking, you're probably going to want to go to Bob or Kate once you see the review letters, or myself, and say, this looks like it needs. It says it needs a D variance. I'm not understanding why, or I'm not understanding something. Call and ask that question before the hearing starts. Better to know so you know what to focus on during the hearing itself. I think I probably said enough for tonight. If there's anything else?
Thank you, Marty.
Any questions?
Any questions for Marty?
I have a few things I'd like to input too.
Go ahead.
As new people, it's difficult for you to absorb everything we heard tonight. One of the things that I think are common mistakes for new people is that when you listen to somebody tell you about their situation that, let's call a backyard variance, and they want to put a pool in or they want to put a shed in, And they say, oh, the hardship is that I can't put it over there because when I look out at my house, I don't want to see the shed. I want to put it, 2 feet away from the property line so I don't see it. That's not acceptable as a hardship. We always have to think of how our neighbors are going to be affected by whatever they put in, because that whatever we approve stays with that property. And they may say, oh, my neighbor's okay with having it 2 feet from the property line, but we're not thinking about the future. If somebody else comes along, or that person that tries to sell their house and they can't sell their house now because the neighbor put a shed 2 feet away from the house. So we always have to think about whatever these applicants are asking us in the backyard variance is not only how does it help them, but how does it affect the neighborhood? And how is it going to look in the rest of the neighborhood? We've had lots of people wanted lighted tennis courts or sports courts in their yards. And we had to spend a lot of time with the lighting and the shrubbery and the heights of the poles to keep the lights, because do you want to see light shining in your bedroom at 11 o'clock at night when you're trying to go to sleep? But for them, they don't think anything of the neighbors. And maybe the neighbor didn't come to the meeting. And somebody might say, well, they should have came if it bothered them, but maybe they work at night and they can't come. So we always have to think of if we were living there next door to this, would we want whatever they're proposing, would it be okay with us? And that's really, it's almost common sense. We listen to all the facts, we listen to our professionals, but keep in mind that most of our cases the professionals are not always there. A backyard variance, we're not going to have the engineer, because keep in mind, we didn't go into this, but the cost of all of our professionals is paid by the applicant. So somebody that's putting in a pool, they don't want to be paying for an engineer, a planner, all to come and give their opinion. Usually we only have Lonnie give us an opinion because she's part of the salary prepaid, let's call it that way. They're not charging the applicant for that. So it's really important too, when we ask for things and we say, well, you know what, why don't you redo the survey and show it to us next meeting? So now that poor person has to pay somebody to fix that, come back another meeting, pay for all the professionals, pay all the expense. And maybe we could have said, hey, let's make a condition that if you do this, then this will be approved. So I'm going to be at obviously most of these meetings, and so is Valerie, and we'll probably be more outspoken than you guys. We'll be jumping in and giving our opinion and hoping keeping the meeting going in a certain direction by asking the right kind of questions for these applicants, because I've lived in Holmdel since '95. So I have a good feeling of every part of this town. And when I see a house, I almost know the neighborhood right away what it is. So we don't want to make one house be different from everybody else's house, where later the neighbors are going to say, why did that zoning board approve that thing? That's terrible over there. And that's really what it's all about here. We're going to use common sense for our neighbors and try to do the right thing for them and for the applicant, and of course for our town, because we have to live with whatever we approve. Whatever building goes in our town, we have to live with it. And Marty mentioned about, what you say, that's very important. If you're going along the line and somebody says, well, I want to have a green house, and you say something like, green, I wouldn't approve this application with a greenhouse, no way, no how. Right away, that already slanted the whole application, because you didn't hear all the rest of the evidence why he wants it to be green. So you can never say things like, I won't approve it if this is not done. You might ask, why do you want a greenhouse? But you're not going to tell them what your decision is before you hear all the facts. That's another common mistake for new people to do. So I don't know, Marty, if I'm saying something that I shouldn't be, you could jump in. But these are the things that as a chairman, I had to sometimes say, oh, wait a minute, don't say those kind of things, because those are things that we later will be sued by the applicant, because they say, hey, that member wasn't for me right from the beginning. He made these statements. He wasn't even on my favor. He didn't even give me a chance. that's what kind of things the judge will overturn, right, Marty?
Yeah, and some things are governed by the building code, which is not really our issue. So it maybe even like colors on a house, but let's say a better example might be, I want to build a roundhouse and it falls within the setbacks and you're like, roundhouse, I'd never approve that. So Dimitri's right. You don't want to ever say something like that. It's already tainted. You've already got the record. It's on the record that you're against roundhouses. Well, you know, if he meets the setbacks, it's not for us to say whether a roundhouse is something that's worthwhile or not, but we need to investigate the other aspects of it. I will say, and I forgot to mention Lonnie too, because if we get these backyards and she may say it needs a variance, and you may say, why is this? It's a shed. Why does it need a variance? And again, if Loretta can't answer it, Lonnie may be able to answer it. She's looked at the ordinance and said, well, it needs to be 10 feet off the line in that particular development. And you may know that as you get into this, you may know different developments, there's different setbacks, and I'll just use the shed, for example. It may be 5 or 10 feet in one zone, but if it's a 2.5, 5 acre zone or something like that, it may be 25 feet. So there's different setbacks for different size zones that we have. And you will find that some of this, we'll see a lot of very similar applications in certain zones. So if you're in a zone that doesn't have the smaller lot zones, anybody who wants to build an addition may have a floor area ratio issue, and they have to come back. They have to come before us just to build a sunroom or something. And again, you'll see a lot of them. And the other people will make a comment, whether it's Dimitri or one of us that's been here a long time. So yeah, we've had this before, and then that'll give you comfort to know that, yeah, that's just an area that they just don't have enough land to do some of these other improvements, or the house has been built by the developer to the full extent possible. Even the new houses over at the Toll Brothers in Bell Works, some of those houses were built to the full amount possible for impervious coverage. So anything anybody wants to do, even though they're very big lots or very big houses, they have to come before us for a variance. And so you'll see a lot of that sometimes. But again, Dimitri's been around, a lot of us have been around. My parents moved here in '64, so I've been here a long time. I am not a voting member though, so I don't get to vote. So my 2 cents doesn't matter, other than if you need background information on legal aspects. But clearly a lot of us have been around a long time to give some background information if it's needed, and reach out to us is the best thing I can say.
Good. Thank you both. Any other questions or comments?
I have something. Just going to this whole thing about some developments are built already up to what they're allowed to build on. So anybody wants to do anything more in addition to swimming pool, and we know there's a lot of developments in Holmdel that are like that, they have to come before the board for variances. Is it a good argument on the point of the applicant to say, you approve this for 5 of my neighbors, why aren't you approving it for me? I mean, does that, is that kind of tainting the whole approval? And my other thing is, if we have developments like this, why aren't we going back to the planning board? Why are these developments allowed to go up that way? If let's say Toll House, who's going to buy a big house like that and not want a patio in the swimming pool? Just doesn't make.
The first point is more a legal thing. I'll let Marty comment with regard to one thing that the zoning board is required to do. After the end of each year, to prepare a report to the township committee about what we've done in the past year. And then Loretta starts putting that together. We haven't done it yet for last year. It just lists the various approvals that were made. But that report gives us as a board an option to suggest, gee, in this particular zone, we're seeing lots of requests. They're reasonable. We ought to change the requirement in the zone, allow 20% coverage instead of 15%. Sometimes those sit and don't get approved, but last year, the township committee, after due consideration, did in fact adopt several ordinances that incorporated recommendations that came from the board. So if it's a unique one-on situation, then we just have to take it as it is. But if it's an entire subdivision is encumbered with a particular problem that we feel it's fair to the neighborhood to modify it. And we can recommend that to the township committee, and they have the ones that have the authority to change the zoning ordinance. Yeah, in terms of this, it is not unusual for neighbors, if they're for a backyard variance, for a neighbor, especially a near neighbor, to come in and say, I like it or I don't like it. And that helps the positive and negative arguments about it. We've had several where the neighbor said, this seems reasonable to me. It's like what I did or not. And the applicant talked to me, I'm content with it. That supports the positive criteria and doesn't add to the negative. Occasionally, there'll be people that will say, I don't care for this. You, Marty?
Yeah, but so every case does stand on its own, Francine.
Mhm.
I will say though, if you have 10 houses in a neighborhood and we've granted in the recent past a variance to put their sheds 2 feet from the line, and then the sixth one comes and says it, and we just don't necessarily like that person or the color of their house, and or the way they present their case, you know, and you deny it. Again, we need to be careful of the record. What is distinguishing that from another? And again, everyone stands on its own, but if they want to appeal it, they will definitely use, hey, this was approved 5 different times on basically the same set of facts. And for some reason, this board decided to vote it down. So we need to be careful. I think we need to be mindful of what we've done in the past, and not stray too far from it without very good reasons.
Yeah, because I'm just concerned, let's say we approved 5, let's say 2 feet from the line. And this particular applicant, their neighbor doesn't want it that way. So they come in, they give us a negative. I don't want that shed near me, but the other argument is, but you've allowed other properties to do it. So I guess we have to look at what the neighbor that's presenting negatives, how strong of the, how strong should that weigh?
Correct. And if we've recommended to the town that they should change the ordinance to 2 feet instead of 10 feet.
Yeah.
You're probably even harder pressed to say no, because we're actually making that recommendation already. We've made it. You'll see a lot of times the town does not change the ordinance that often. So we make the same recommendations year after year. And so a lot of these will come up just because, and then, this board will generally, if there's really no differences, use the shed as the best example, because it's a minor accessory use. But if it's 2 feet and everyone's 2 feet, even if there's an objecting neighbor, they may be, we may be hard pressed to change course when we've already recommended to the town that the setback should be 2 feet and not 10 feet.
Yeah, but Marty, we can also say, well, applicant, if you put some shrubs there to help screen it, then perhaps it would be okay.
Absolutely.
So we can make suggestions of some sort to help that applicant get his approval.
Correct. And that happens all the time, especially on the bigger applications. There's always back and forth with a lot of different recommendations. You'll see too, especially the new members, there's always the lighting level. There's a standard of 1 foot candle, underneath the light, and it can't spill out. And our ordinance is written such that Kate will tell you that, or Bob, that shows up on almost every, commercial application, because it's very hard to achieve. And we've made comments before. So it's like if it's a repetitive kind of variance, and generally we're not going to deny it for that, because we've given it before, we've recommended to the town that 1 foot candle standard just it's not practical. So I think on those, especially where we recommended to the town, we need to be careful straying from what we've told the town.
Marty, just as a quick side note, both of those that you mentioned, but I know it was just examples, but both sheds and lighting requirements for commercial properties were part of the package of changes that the township committee did make over the summer. So, and I think that's a good example of how the zoning board, you operate independently, but you have this opportunity every year to let the planning board and the township committee know what's going on with certain ordinances and how that's affecting both, for the most part with these backyard variances, for the same reason that Bob and I don't usually get involved, is because you're not trying to make life harder for residents of your town.
Right.
That has to do with, with the sheds and something like that. And just I know we're probably going to wrap up soon, but just the last thing I would just say with regards to like certain neighborhoods and the same people coming in with certain things is that in many cases that they might have the same hardships on different lots. If all the lots are narrow on this side of the street, or if there is a stream running behind it, so even though every application does stand on its own, every pieces of property in the same neighborhood can all have similar qualities in that sense. So yeah.
Hey,
Thanks.
Marty, one more thing you should bring up again. You talked about people were in retailing, it's a big thing. So if somebody owns a store and they're coming in and you happen to shop at that store, does that mean you should recuse yourself? Or you happen to be going to that church and the church is asking to do something, do you recuse yourself? So can you talk a little bit about that?
Not shopping, but if you are a member of a church and if it's Dimitri's church, he probably should recuse himself. He should recuse himself. But if it's a church where 5 members are members, they should recuse themselves. And then if by necessity, we would need to bring in members from the planning board as crossovers for that one application. But it's very specific. So there's actually case law on it. So you could be a member that does not attend church very often, maybe once a year. And yet you have another member that maybe not only attends every week, but it's a trustee. Clearly there's a different level of involvement and the court actually recognizes that. So we would have to determine what your level of involvement is when it comes to a house of worship or something like that. But shopping at a store does not in and of itself result in a recusal. It could be Exxon coming in, you can have a share of Exxon. That's not deemed to be having financial benefit because it's such a huge corporation. Your share is meaningless essentially. But if it's a privately held, or even if it's public and you happen to be a 20% shareholder, that's a different story. So facts are important. And if you believe there's any connection to the applicant, just call me or let's talk about it. You can talk about it on the hearing too. There's nothing secretive about it, but probably better to know ahead of time, talk it out and know what you're going to do when the question comes up. Does any of the members of the board have a conflict with the applicant?
And not just the board members, but it's also the professionals.
And it's your family members too. So it could be your spouse. Your spouse could be the shareholder of a privately held corporation. That's important. You need to say that you think there's a conflict.
Yeah, our professionals do have other clients. And sometimes, if one or another of them does have a conflict, then we will find another professional to fill in for that application.
Yeah, and the applicant's attorney may have represented one of you on an ongoing basis. Now, it may have been 20 years ago on a house purchase. That probably is not enough to say that that's your attorney. But if you are currently in litigation or with some project or you repetitively use the same attorney on projects constantly, and in the most recent past, probably yes, definitely going to be a conflict there, and you'd recuse yourself because the applicant's attorney.
Okay, unless there are 2 people have been listening in from the public, I think it'd be appropriate to let them give a chance if either one of them have a question at this point in time, since the main purpose of this whole thing is informational. I guess probably the right appropriate way is if either of you would like to raise a question, use the raise hand button. I'm not seeing anybody raising their hands. Nope. Okay. Well, with that, thank you all. Thank you, Bob, Kate, Marty. Hopefully this is informative, and I think you'll find especially the new folks, it's a continuing learning progress situation as we go through the year and as we hear different cases, things will come up. I mean, in terms of unusual situations, one other area in town which wasn't mentioned previously is Holmdel Village. A lot of Holmdel Village predates when zoning was enacted. So that there are another category of rationale for things, it's pre-existing. The house was built here on the lot before you introduced your zoning ordinance. And then when that case is heard, we'll take that into account and those facts will be reflected in the resolution. So unless there's anybody else has any other questions, and not seeing anybody, I believe that's the end of our business for this tonight.
Excuse me, Ralph,
Yes,
want to remind everybody, the next meeting is on February 16th via Zoom, and that will be the Dementia Center.
yeah, it's a continued public hearing and, we'll talk about that hearing at that hearing. And
So
not-
they decided they wanted to do a Zoom meeting instead of live?
They have accepted that proposal.
Wow, okay.
At least for the February meeting,
Yeah, beyond that is another story.
right?
Things are getting better, but it's still some difficulties. Okay, is there any other business for this evening? Seeing none, is there a motion to adjourn?
Motion to adjourn?
Second,
I'll second it.
all in favor?
Yep.
Aye.
Aye. Any opposed? Thank you all. I hope it was informative for you. And just to reiterate, if any of you have any questions, please don't hesitate to reach out to myself or Bob, Kate, Marty, and we'll see you